right, well, welcome to our panel on perspectives on national security and the war on terror. My first responsibility is to remind you to turn off your cell phones, put them on silent. So my name is Dawn Johnson, and I teach constitutional law at Indiana University Maurer School of Law in Bloomington. Also a longtime ACS board member, most relevant to this panel, served in the Department of Justice's Office of Legal Counsel under Bill Clinton. Tried to go back, but that didn't work out. It's my great pleasure and privilege to introduce to you our panelists. I'll do that first, and then introduce our subject a little more. So we are very fortunate to have an exceptional group of panelists, all of whom are experienced, distinguished, thoughtful commentators on the many difficult issues confronting our nation post 9/11. And I'm going to give you very short introductions. You have longer biographies in your materials. Just quickly, moving alphabetically here, we have welcome John Bellinger, who is a partner at Arnold & Porter, also an adjunct senior fellow in international law at the Council on Foreign Relations, and a senior contributor to Lawfare blog, which is an excellent source of information. Served in the Clinton administration as a career lawyer in the Department of Justice, and then in the Bush administration as the legal advisor to the National Security Council, and then the legal advisor for the State Department. We have David Cole, law professor at Georgetown. David also has long served as an attorney, volunteer attorney for the Center for Constitutional Rights, is the legal affairs correspondent for The Nation, a regular contributor to the New York Review of Books, the reason I subscribe to the New York Review of Books. David's the author of 6 books, most recently, The Torture Memos, Rationalizing the Unthinkable. Jamil Jaffer has been with the American Civil Liberties Union since 2002. Good time to start there for our issues. He currently is the deputy legal director of the ACLU and the director of the ACLU's Center on Democracy, which houses its work on national security, human rights, free speech, and privacy and technology. He's very busy these days. Marty Lederman, also a Georgetown law professor. Marty served with me. He served as a career lawyer in the Department of Justice's Office of Legal Counsel during the Clinton and Bush administrations. Then at the outset of the Obama administration, Marty was permitted to return to the government to help lead the Office of Legal Counsel as Deputy Assistant Attorney General. All right, now, so by brief introduction to our many interesting issues, it's very tempting to say that the issues of the last few weeks make this the ideal time for us all to gather to talk about issues of national security and civil liberties post 9/11, and I will say that, it is true. But thinking back to, I've been at every ACS convention for the last 7 years, and most years I felt that way. I mean, I just have all these memories of about this time, most years, extraordinary things happening on these issues. So this time around, we have the President Obama's May 23rd speech on national security, which was the second major national security speech of his presidency. And just you'll recall that in that speech, among other things, President Obama, he renewed his commitment to close Guantanamo. He addressed the standards and procedures for the use for targeted killings using drones. He also, I think most remarkably, called for the revision and ultimate repeal of the post-9/11 authorization for the use of military force and an end to that war. So if that wasn't enough, then just over a week ago, the president addressed the unauthorized disclosure of 2 major surveillance programs that have been in effect secretly for years, apparently. So as the panelists have agreed, I'm going to lead a discussion of these issues for about an hour and then open it up to your questions. And I am going to use the President's recent remarks as, if you will, as a prism for looking at the last 11 years or so of policies. I'll introduce each question by reference to the President's recent remarks. So first, before we get to some of the specific issues, and one thing we'd like to do, the panel agreed to dispense with long opening comments so we can get through at least introducing lots of these interesting issues and get to your questions. We're all going to feel like we're rushing and being cut short, so I'll warn the panelists that is how we'll all feel. But to start off, I'm going to invite each panelist, just going down alphabetically, in kind of a lightning round to try to keep yourself to just a minute or two, 1 point in reaction, general reaction to the President's recent remarks in the, I think the most significant is his May 23rd national security speech, starting with John.
Great. Thanks, Dawn. And I just want to say extremely quickly how happy I am to be invited here to do this. I don't normally agree to speak on Saturday mornings, but I agreed to do this in particular because I think, frankly, that bipartisanship and sort of a broad ideology is important. I was invited to Yale Law School when I was legal advisor about 7 years ago to come and speak on national security issues, and I said I would not speak just to the Federalist Society. I wanted to be co-hosted by the American Constitution Society and the Federalist Society. And so if I leave you with one message today, and I will say this at the end, it is that we really need to restore bipartisanship. It is very easy to demagogue these issues from either the right or the left, and we really need to try to get back towards the middle because these issues are hard. 2 issues on the President's speech. I guess I will say one, that I was maybe disappointed but not surprised that he spent a good chunk of his speech blaming a lot of the problems of this administration on the last administration. 4 years in, again, I just think that is not healthy. It is, and I understand it's political, but if we want to rebuild bipartisanship on these issues, the way to do it is not to blame everything on the last administration. The fact is, for those of us who have served in government, these issues are hard. Governments make mistakes, that is true, but the issues are difficult. The thing that did surprise me, I guess, was the extent to which the President distanced himself from some of his own policies. He seemed to be sort of suffering from cognitive dissonance in his own speech. He distanced himself from the drone policies, the targeted killings in the first term. He distanced himself from the authorization to use military force, which they have taken pains to rely on. And he distanced himself from leak investigations approved by his own Attorney General. So that seemed to be sort of odd. The President seemed to be wrestling with himself. Now, I get it, because in the second term, when I moved and became legal advisor at the State Department, when your first term has not gone the way you thought it was going to go, and you have to sort of work to reset, I understand that this particular period of time can be difficult. I'll just end on something a reporter told me about the speech, which I thought was amusing. I won't take credit for it. Was the press said that for 4 years they had been hearing the mantra from Obama White House officials, "We are not the Bush administration." And now the new mantra for the second term is, "We are not the Obama administration."
So I want to thank ACS for putting on the panel and for inviting me to be part of it. This is a tremendously important organization in the American legal fabric, so I'm happy to be here. As you might imagine, I'm not so troubled by blame being cast on those who did wrong in the past. I think actually that part of moving forward is acknowledging wrongdoing, and one of the weaknesses of the United States in this whole area is the unwillingness to acknowledge wrongdoing. We have a 6,000-page report from the Senate Select Intelligence Committee that apparently acknowledges a lot more wrongdoing than we even know about, but it's entirely secret. And I think we need to be more comfortable with acknowledging where we went wrong if we're going to go right. I think this was a tremendous speech, though, and I see a real kind of evolution from the only other speech he's made on national security, which was May 2009. I think that speech was the rule of law speech. That speech differentiated himself from the Bush administration in the notion not that we're not going to use military force, but we're going to do it within the bounds of the rule of law, not the position of the Bush administration. We will do whatever is necessary and disregard and try to put on some obscure island the rule of law so that we can do whatever we want. That was a rule of law speech. This speech was a peace speech. This was a speech that said, I want to be the president that goes out of office having ended 3 wars: the war in Iraq, the war in Afghanistan, and the war against al-Qaeda. And I think that is a tremendous goal. And if he is able to succeed in that goal, then he will have earned the Nobel Peace Prize that that he got a little bit early.
Jamil.
I too would like to thank ACS for inviting me. I think there were many good things in the president's speech, and I agree with what David just said. I think that to me the trouble is that there were a lot of rhetorical commitments made in the president's speech. A commitment to end the war, a commitment to close Guantanamo, a commitment to tighten the restrictions on targeted killing, all of which we at the ACLU welcome. But it's one thing to say we should end the war, and another thing to actually end it. I worry that what we have is the rhetoric of peace, but the reality of war. That while the president is saying that he wants to end the war, in many ways we are entrenching the very war that the president says he wants to end. I'm sure we'll talk more about that. But the only other thing I wanted to say about bipartisanship, I'm not as enthusiastic about bipartisanship as a lot of other people are. I mean, I think it's a good thing that people agree if what we're agreeing on are the right set of policies. But I think what we're starting to see is a kind of indifference of the security state to the administration, to the character of the particular administration. It doesn't matter who's in power. These policies just seem to grow and grow, and I think that the surveillance disclosures of the last week are some evidence of that. That the logic of these security policies is so strong that it doesn't matter that much who's in power. And I think that, I'm kind of overstating the case in order to make the point, but I think that there is some truth to that, and I think that that's a very unhealthy thing for our democracy.
Dawn, and thanks to ACS and to Dawn for convening this. It's a pleasure to be here. John and David and Jamil and I talk about these issues fairly incessantly with one another, and it might as well bring you all into the conversation and see what you have to say about it, which is really true. And I think all of us were encouraged by the president's speech. My sense, and it's been a couple years since I was in the administration, but my sense is that this was very much, and this was reported in the press, and everything I heard was, this is really very much from the heart and what the president believes, and it took a lot of work within the administration to be able to say some of these things against great resistance from some of the agencies, particularly with respect to the president's desire to cut back on certain authorities or not exercise them or put them in a certain legal framework or policy framework that would be a precedent for this conflict and for other conflicts going forward. I think, Dawn, we'll probably get to all of it in the conversation, so I guess I could just start listing some of the things that were most striking to me about it, but I think, why don't we just do that in the context of your questions and our discussions.
Okay, and I promised Marty to ask you about that new framework. That will be soon. First, that'll be second. First, I want to start with Jamil, and start with one of the rhetorical commitments, and hopefully the emphasis on commitment there from the president's recent speech. Actually, a common theme of both of his national security speeches was the critical importance of government transparency in the functioning of our democracy, which is an issue close to the ACLU's heart, and many of our hearts in this room, I think. So here I want to read from the president's recent speech very briefly. The president said, we will have to keep working hard to strike the appropriate balance between our need for security and preserving those freedoms that make us who we are. That means reviewing the authorities of law enforcement so we can intercept new types of communications, but also build in privacy protections to prevent abuse. And so he also talked about striking the right balance between our security and our open society. So, of course, shortly thereafter, we had the revelations about surveillance that I assume we're all aware of. Just want to emphasize we don't know all the details. The president did, though, address the phone surveillance part of it. And there, and this one I asked Jamil about it in particular. And let me just say, we had a panel yesterday all about surveillance where we got deep into the legal weeds, and we won't have time to do that. This is just one of several issues, but I want to talk about surveillance with Jamil and transparency on a more general framework. So the president emphasized that he was not acting alone. The FISA court had approved the surveillance. He had, and he also made an interesting distinction regarding the secrecy of the program that I want to highlight. He said the programs were secret in the sense they were classified, but they were not secret in the sense that our elected representatives in Congress were briefed on the programs, and federal judges were overseeing them. And so here I cannot resist quoting John Oliver, that great political commentator, who some of you may have seen the day he took over for Jon Stewart, hosting The Daily Show. He said, Mr. President, no one is saying that you broke any laws. We're just saying it's a little bit weird that you didn't have to. And of course, then Jamil filed a lawsuit claiming the president was breaking laws. So Jamil, here's a question. Why do you find, you've been a leading critic and argue bad legally and as a matter of policy, why do you feel that the checks that the president described, he is, I think, approaching it differently in fully briefing Congress? I accept that. Why is the oversight of Congress and the FISA court, in your view, inadequate? There's a leading question for you.
Well, I guess I would distinguish between the two programs, the PRISM program, which is a content program, and the what people are calling the metadata program, the Verizon program, or the program that's focused on Americans' communications and the metadata relating to Americans' communications. So with PRISM, I think that the problem is the law. With the metadata program, I think that the problem is the program itself. I think that the program exceeds what Congress meant the executive to do under the Patriot Act, and you don't have to rely on the ACLU for that. The people who wrote the Patriot Act are saying this isn't what we intended. Representative Sensenbrenner said that a few days ago. In terms of the checks and balances that apply to these programs, many members of Congress, most members of Congress didn't know about this metadata program. They didn't have access to the OLC memos. They didn't have access to a lot of the crucial information about the scope of the program. And there's an important question about whether that was a failure of Congress or a failure of the administration, and I think that's an important question to resolve. But the fact remains that many members of Congress didn't know about the program. So I think that it's not true to say that there was congressional oversight. As far as the court is concerned, the FISA court is structurally not capable of providing what we ordinarily think of as judicial review. The court meets in secret, allows only the government to appear before it, rarely publishes its decisions. Everybody knows, the basic statistics. Over the last 30 years, they've heard some 30,000 surveillance applications. Only a handful of those have been denied. Structurally, it's not made to be a real check on government surveillance. And something that I think a lot of the news articles have overlooked is that the court doesn't even have the jurisdiction to consider many of the objections to these kinds of programs. It doesn't have the jurisdiction to consider First Amendment arguments. It doesn't have the jurisdiction to consider Article III arguments. For example, the argument that the court is violating the Constitution by reviewing generalized programs of surveillance rather than individualized surveillance applications. Those aren't questions that the FISA court has the authority to address. And so, I think that those checks are insufficient. And if I just say one more thing, I think that the focus on the other branches is useful and necessary. To what extent did they know? To what extent did they exercise the oversight that we expected them to exercise? But ultimately, the most important check on government power is public oversight. But the public knew nothing about these programs. The public didn't know that they existed. The public didn't know their scope. The public didn't have access to the OLC memos, didn't have access to the FISA court's opinions. And everybody recognizes that a certain amount of secrecy is unavoidable in this area. But it's one thing to say the public can't be told who it is that we're surveilling, who specifically we're surveilling. And another thing altogether to say the public can't know that the government engages in this kind of surveillance at all. Or on what legal basis it engages in this kind of surveillance. And that's the kind of secrecy that we object to, and that's the kind of secrecy that I hope this leak will put an end to.
Thanks. So for each of these issues, I'm going to ask one of our panelists to open and then invite others to volunteer to comment. Before I open it up, I'm going to put John and Marty on the spot as former executive branch lawyers, and maybe first John, then Marty, to help us understand why might the executive branch legitimately want to keep the, or not legitimately, but what's their incentive? Why do they feel, before we get to your own views, why might the executive branch feel it's important to have secrecy with regard to the existence of these programs or some of the details of these programs?
I guess that one's pretty easy. To say it's a secret program because we don't want the terrorists to know what we are doing. I don't know all the details of these programs, but they basically seem to be successors to the things that had been started in the Bush administration. And the key thing here is that they have been approved by all three branches of government, including the executive branch, the Attorney General, the President himself. These are people that you in this room presumably trust. And I can tell you, as someone who has sat in the Oval Office, the President wrestles with these issues. So the President, Attorney General have wrestled with these and concluded that they have sufficient balances. The FISA court has approved them. These are federal judges. Congress has been briefed on them. If they haven't attended the briefings, that's their fault, but they have been briefed over and over and over. So, this is the American Constitution Society. All three branches of our government have approved these programs and have concluded that they are sufficiently limited. With respect to the FISA court, as the only person in this room who is probably, I don't know everyone in this room, but I've probably read more FISA applications than anybody in this room. If you read a FISA application that's got about 500 pages of then this terror suspect did X, and then they did Y, and then they did Z, and then they talked to this person, and then they talked to that person. By about the 500th page, you say, no kidding. There's probable cause to think that this person is actually up to no good. I was in the Situation Room on 9/11. It changed my life. It changed my family's life. My family didn't see me for about the next 8 years. You try very hard to keep the American people safe within the bounds of checks and balances. I spent a lot of time with the 9/11 Commission, who told the Bush administration, you did not do enough to keep the American people safe. So certainly the lesson of that was that the American people expect their government, all three branches, to do everything that is necessary to protect them from terrorism, but within the law. And in this case, it has been within the law, all three branches of government. And I would say, last thing I'd say is simply, that the programs, I think, seem to be much more limited than they have essentially been sort of demonized in the press. The PRISM program only involves contacts between foreign nationals, and the metadata program is basically connecting the dots that seem to have failed in the run-up to 9/11, where the government had different dots that the American people expect them to be connecting.
Marty, do you have anything to add from the perspective of the executive branch?
No, not from, well, yes, from the perspective of the executive branch, but with
And then tell us what you think.
But with the caveat that, nothing I'm going to say is based on particular things I learned about surveillance or these or other programs, and so please don't read into it anything about that. But I can talk in general, and from what I've read in the paper, what I'm about to say as a general matter, probably applies to these programs as well. So this is a good question, Dawn, as Jamil and John have sort of framed it. It raises two of the principal issues we wanted to discuss today. The first is, is the importance of checks and balances and of the working with the other two branches. How important is that? Because that is a very, very central tenet of the president's national security objectives and his program and policy, has been to ensure that he will abide by statutes, right? That Congress has the last word, and then he's not asserting a constitutional power to act in violation of statutes. Now, that's the principal thing that I, for instance, criticized about the Bush administration before it came in, and not all the Bush administration. I mean, John and others worked very hard to bring their policies within statutory limits, but certainly the claims being made, especially in the first part of the Bush administration, of an authority to act in disregard of statutes is something this administration has abandoned, and to its great detriment, right? The president, if the one striking thing about the speech is that he's had his hands tied. One of his principal objectives, the best way of prosecuting this armed conflict, is to close Guantanamo. Keeping it open is costing the United States dearly, according to the president, and yet Congress has prohibited him from doing what needs to be done to close it, and he's abiding by those statutory limits, much to his chagrin. I think that's an important point, that if we pass statutes, if we're concerned about the surveillance, and if you pass statutes that would limit the executive or structure it or provide minimization rules that we think are reasonable or more robust judicial oversight or more robust transparency rules, this administration and I think future administrations would abide by those statutes, and I'll come back to that. I agree with Jamil that it's not as, the checks and balances that are internal to the FISA court and the Congress, and in particular the intelligence committees, are not as robust and as thorough as public discussion might be, but they are not trivial. So I'm somewhere in between. Within the executive branch, knowing that you have to go to the FISA court and justify yourself, and that court has actually ruled some of the minimization requirements unconstitutional. Apparently, there's this opinion that's being the subject of current FOIA lawsuits. And having to go to the intelligence committees, which they do several times a day, and brief them in excruciating detail of all of these national security things, that imposes real practical constraints on the executive branch. If you know you're appearing before the FISA court and the intel committees and trying to justify what you're doing on a virtual daily basis, that is no small thing. I'm not disagreeing with Jamil. I just don't want to lose sight of that. And that has been a principal commitment of this administration, and I think a very good thing. I'm sure John would say he was probably up on the Hill briefing them every day too, so he knows of where I speak. It's a pretty significant thing. It constrains what you do. So what about transparency and secrecy? I actually think one of the virtues of the debate over the last 10 days has been that it's required the executive branch and the Congress, in some sense, to come forward with, broadly speaking, the rationales for secrecy in this area, and there are two principal ones, and they're not what the public discussion usually focuses on. So the public, it's usually, the administration wants it both ways, the executive branch and Congress. They want to be able to protect against embarrassment. They don't want anyone to know the wrongdoings that they're committing, or they don't want to have political difficulty. That's why they keep things secret, or they want to be able to tell half the story, only the half that makes them look good and not the half that doesn't. And of course, there's some of that in every government throughout time, but I actually think that what's driving covertness and secrecy and non-acknowledgement more than those things in this is an administration that would love to put on the table many more of the details, for instance, about the use of force overseas, because it wants to tell a story that it thinks is much better than the story that's been told in the press about the use of force. There's two reasons it can't do so that have both become prominent in recent days, and John raised one of them, right? So one of them you hear all the time is, we can't tell you what our capabilities are, either our legal capabilities or our technological capabilities, because that will tell the enemy what we can do and change the enemy's behavior. We exploit the fact that the enemy thinks we can't do something, whereas in fact we can and are doing something. And we want to be able to continue to exploit that. We all think that that's okay in some sense, right? You wouldn't tell the enemy that you've been able to crack their codes, right? No one would think that should be transparent. But on the other hand, Jamil's right. At some broader general level, especially when it touches upon U.S. persons, there's something disturbing about the fact that the American public was unaware of an apparent metadata sweep of all of their phone calls from general carriers. And the idea, and I am actually troubled by this rationale, by the idea that we are kind of taking advantage of the fact that those who we are trying to stop from committing terrorist acts are more subject to our surveillance if they don't know what we can do. It's obviously true, but it runs into this problem of democratic legitimacy. The other argument that you've seen, and it's very interesting, and I think actually more important, is we couldn't tell you this because this, like virtually every other form of national security operation, depends very heavily on the cooperation of non-U.S. governmental entities, whether it's another country who wants to cooperate with us but doesn't want to acknowledge that it's cooperating with us, or corporations, right? The most interesting thing when this broke was, I'd have loved to have been a fly on the wall in the Verizon offices, right? That night as they're losing market share, and you basically started hearing in the press, now they all want to make it all public because they all want to be, it's not just us, it's every telecom company that's cooperating with the United States. Don't blame it on us. The need to not reveal the fact that we are cooperating with others and that a condition of that cooperation is often that we not acknowledge that cooperation. This is the lifeblood of modern diplomacy and national security operations. And it is, I actually think, the principal reason, it's silly to say it's the principal reason, it's a big reason why there is often a need for non-acknowledgement. It's not secrecy as such, because even when something seems to be widely known, the government can't acknowledge it because it's promised it won't do so as a condition of gaining cooperation. Now that's blown to smithereens here, right? Because now the telecoms, apparently we know that they were cooperating, and now they want to put it all out on the table. So that rationale for secrecy is sort of beside the
gone.
point.
We'll see what happens now.
And now we're falling back on the one that John raised.
No, I'd like to ask David if he wants to weigh in. And let me just say we're about at the end of what I had allotted for this issue, but we're going to hear from David and then let Jamil have the last word and move on to our next issue.
So I want to underscore something Marty said, which is I think there's a real difference. It's not quite accurate to say this is a continuation of what was being done by the prior administration. In some sense, they're still gathering a lot of electronic communication data. That's a continuation. But the real difference is that President Bush was doing it in a warrantless, criminal way. There was a statute on the books that said it's a crime to gather this kind of information without a warrant, and he just went ahead and did it without a warrant. And in fact, it nearly precipitated the resignation of virtually the entire leadership of the Justice Department because of the illegality of the program. Whereas President Obama is continuing to gather some of this information, and in disturbingly broad ways, but pursuant to a statute which has been revised to authorize broader surveillance, and pursuant to warrants that have been approved by courts. And those are not trivial checks. That said, I think it's deeply, deeply problematic that this has been as secret as it has been. And it's a problem that, goes across issues. So when John Brennan, was it John Brennan? I can't remember whose hearing it was. Recently, there was a hearing in which Carl Levin, the head of the Armed Services Committee, was asking the administration officials, who are we at war with under the AUMF's Associated Forces provision? And they said, well, we'll have to get back to you on that. When the head of the Armed Services Committee doesn't even know who we're at war with, that's a problem in terms of transparency. Until the day before the speech that President Obama gave on May 23rd, the administration had killed 4 American citizens and countless others, and had not acknowledged the fact that it had killed them. Here the president is asserting the power to take an American's life and to take many non-Americans' lives, and not even acknowledge that he has done so. That kind of secrecy is deeply problematic. And then on the surveillance program, we had Ron Wyden ask James Clapper point blank, with advance notice of the question, are you collecting any kind of data on millions of Americans' phone calls? And he says no, which is a flat-out lie. He later says was the least untruthful answer he could give, which is clearly false. The least untruthful answer would be the truth, and one version of the truth which would be we can't confirm or deny, which is one that they do all the time. But no, he lied to us. He lied to us. And I just think that you can't have a democracy governed by the rule of law, no matter what the internal checks and balances are, when decisions of this moment, who we're at war with, who the president can kill, and to what extent they can spy on all of us, be entirely secret.
Jamil?
But David just said a lot of what I was going to say, so I agree with all of that. But you know, just last night, at actually 11:55 last night, the Obama administration filed a brief in a FOIA case, it's now in the Second Circuit, relating to the targeted killing of American citizens. And you know, I was talking earlier about the distance between rhetoric and reality in the president's speech. And one of the things that the president said in his speech, and that was said, you know, by many administration officials, both before and after the speech, is that we are thinking about releasing more information about the targeted killing program to allow a more informed public debate. But the position that the administration is taking in that litigation, still in the Second Circuit, is that the government is not required to release any more information than has already been released, and that in fact it can't even disclose the number of OLC memos that have been written on this topic, let alone their subject matters or let alone their content. So you know, I think it's very difficult to say that we have an informed public debate about these national security policies when so little is known about what the government's policies actually are. We don't know who we're at war with. We don't know in which countries the government is carrying out targeted killings. We don't know on what legal basis it's carrying out those targeted killings. There's a similar kind of secrecy surrounding all of the surveillance programs. And then, I'm sorry that these points are a bit disconnected, but just to respond to something that John was saying, you know, John was describing the FISA court process, the FISA process in which the government submits individualized applications to the surveillance court, saying, here is the reason we believe there's probable cause to spy on this particular person. That was the system until 2008. In 2008, Congress passed this statute called the FISA Amendments Act, which does not require the government to submit individualized applications to the court at all. Instead, what it submits are these generalized programs of surveillance, under which the court's only role is to ensure that the targets are outside the United States. We now know that the way that the government does that is on a 51% basis. So if they have 51% certainty that the person is outside the United States, they assume that the person is outside the United States. And a lot of people have said, well, this is all about targeting people outside the United States. We inside the United States have nothing to worry about. Even if you put aside, even if you assume that people outside the United States have no privacy rights whatsoever, and we shouldn't care at all what they think about this, this kind of generalized surveillance program, which allows dragnet surveillance of international communications, not just foreign to foreign, but one-end domestic communications, is a program. These are programs that have very significant implications for Americans' privacy. In fact, when the Bush administration was trying to justify this new statute to Congress, was advocating for the new statute to Congress, it said that its principal purpose was to allow the dragnet surveillance of Americans' international communications. So I think it's, that's just to say that I think it's a little disingenuous to say this is all about foreign-to-foreign calls. It's not. If it were about foreign-to-foreign calls, there would have been much less criticism of the statute. The criticism of the statute was because the statute allows the surveillance of Americans' communications.
I have so many follow-up questions I would love to ask on this issue, including, I think more transparency definitely is needed, but it gets difficult when you get to specifics. I'm not going to let you answer this question, but what specifically should the administration release going forward now about these programs, I think is an important and surprisingly difficult question, which maybe we'll get to, but I want to spend all the time in this issue and the next 3 issues. So I'm going to move on. They're all related. One point that both David and Jamil made is a great transition. They asked, who are we at war with? The administration cannot answer that. So I'm going to quote President Obama's national security speech, his first one, in which he said, "Let me be clear, we are indeed at war with al-Qaeda and its affiliates." That was his answer then. This is going to be for Marty. Last month, the president said, "This war, like all wars, must end." So my question is about the source of executive authority to take these counterterrorism measures. What was, until now, the Obama administration's view of the president's authority to take these measures? And what does this change in the president's description of going forward? The mindset of the administration will be in ending this war and even repealing the AUMF. What does that do to the source of authority? And here, I hope in 10 minutes to cover the source of authority for, among other things, the detention, treatment, and prosecution of suspected terrorists. So Marty, in 2 minutes, can you explain that, please?
All right. This is my take on what the president was saying about the use of force, but I think it very much applies to detention as well, which I hope we'll have more time to talk about, detention policy. Because one thing that gets sort of glossed over now because it's not even an issue anymore is, 2 things the president emphasized in the speech is we will no longer torture and we will no longer and never should have engaged in this widespread indefinite military detention in this kind of conflict where there's no obvious answer to what to do with the detainees once you have detained them, the Guantanamo problem. So he hasn't added to that problem, and he's basically made it impossible to go forward with that, I hope, in future administrations as well. So I think when he's saying that the war model ought to end and be phased out, the one important thing, I hope most of you saw the speech or read it, is that there's 2 parts of it. One is with respect to the next 16 months or so, and as long as our troops are on the ground in Afghanistan. And that's a distinct and separate problem, and troop protection and the use of force to protect the troops. The president was describing a particular structure and a particular paradigm, a particular model that he hopes will be phased out completely or almost completely in the next year and a half. And after that, what he's saying is to think about this in armed conflict terms. It's going to be limited by the AUMF in that we are not at war with every terrorist, and we are not going to use force against any group that might have some hostility toward the West or toward the United States that might present some risk. That's not the way the West has always dealt with terrorism. We've waited until groups have engaged in attacks against us. But we are at war with particular groups. We will continue to be at war with them, but we will try to move as much as we can away from the war model in 2 ways. One we've already done, no indefinite long-term military detention, and the other is a diminution of the use of force on a status-based basis, right? Not simply using force against someone because they happen to be a member of the enemy's armed forces, but limiting the use of force to those groups and within those groups only to those persons who present a certain level and immediacy of threat or a certain degree of threat, and even then with a strong preference for capture, a strong preference for having our allies, the host countries, deal with the problem before we use force, and a very strong presumption, in fact almost an irrebuttable presumption unless the president says otherwise, against any civilian casualties at all. Now those are all rules that are not ordinarily applied in armed conflict. Armed conflict allows you to do all those things that the president is saying under his new policy outside the Afghan theater will be phased out going forward. So though the AUMF Dawn limits the scope of the groups against whom they will act, but on top of that, the president is saying he is imposing constraints that are not ordinarily imposed by the laws of war themselves.
Okay, John?
So let me say 2 things. One, some of the things you heard about sort of the bashing of the Bush administration stuff that I really just hate to get into because that is not I don't like to do that. When I was the legal advisor to the State Department, I never gave a single political speech. Not one. I never criticized the Clinton administration in which I had served. I never said, well, The reason for 9/11 was actually because the Clinton administration had failed the American people. I do not think that is the role of government officials, and I reject what you are hearing in terms of the sort of the national security partisanship and division. I hope many of the people in this room will serve in government. When you are in government, you have got to work with Republicans, you've got to work with Democrats. And the way to do it is not to go sort of bashing the other side, calling them criminals, impugning their motives. It's just not helpful. Now, let me turn to the substance. And this is because I was not going to otherwise address this, but in terms of the the idea that the Obama administration has not added to the detention problem. Okay, so they've not sent more people to Guantanamo. What they've done is two other things. They have tripled the number of people in Bagram, so that 3 times more people were held indefinitely in Bagram under the laws of war. They refused to give habeas corpus to people in Bagram, whereas the people in Guantanamo did have habeas corpus. So let's just be a little careful about the finger pointing. These issues are difficult, and rather than engage in finger pointing, let's look at what's actually going on. So instead of detaining people, the Obama administration has killed something like 3,000 or 4,000 people. So let's try to move away from the finger pointing. In terms of what the president actually said as a legal matter in the speech, though, about the AUMF, I found it perplexing in that I would very much like to move away from the war footing. I thought some of the criticism that the president attracted from the far right was unfair, inflated, overblown. I really don't like this sort of criticism from either side that's overblown and unfair. But what was odd, though, is that there does need to be a legal basis for the president to take action to defend the country, unless the idea is we don't want the president to take action to defend the country. So the president, in a good part of his speech, said, I'm going to continue these drone strikes as long as is necessary to defend the country. Well, what's the legal basis for that? At the same time, he said, I'd like to repeal the AUMF. Well, the only other legal basis to use a drone strike to defend the country would be to base it on the president's constitutional powers. Well, the president, though, has criticized the previous administration for relying on constitutional powers. So if you start with the premise that the president is going to need to take action to defend the country, then he either relies on an act of Congress or he relies on the Constitution. Now, which would you prefer? Would you prefer to have an act of Congress from the elected representatives of the American people that cabin what the president can do? Or would you prefer that the president repeal that authorization to use military force and simply rely on his inherent powers? Remember, President Clinton had launched something like 95 cruise missiles against al-Qaeda based only on constitutional powers. Now, maybe what the secret hope here is that the terrorist threat will just go away, and therefore the president won't need to rely on either the AUMF or on constitutional powers. I would like that to happen as well. But as long as we assume that there are still going to be terrorist threats and the president is going to need to take action, then I think there ought to be legislative authority for him to do that. That's with respect to the drone strikes. With respect to detention, many of the people in this room, certainly on the panel, know that probably no one in the Bush administration worked harder to get Guantanamo closed than I did. There are people, though, that this administration has said are going to either need to be prosecuted or are going to need to be detained. If you repeal the AUMF, then what is the legal basis to detain them even before they're prosecuted? What would the legal basis be to detain Khalid Sheikh Mohammed? Or is the president saying, well, if we repeal the AUMF, then Khalid Sheikh Mohammed should just simply be let go? There needs to be legal bases for these things. I get the point that we would like the conflict with al-Qaeda to be over. Certainly, I had not planned to spend the last 12 years of my life, dealing with these issues either, but we can't just sort of wish it away.
Okay, I'm going to ask David to weigh in on this and also answer the next question, which has already been raised a few times, and that is your feeling about what President Obama has had to say recently about targeted killings with drones and whether that has assuaged any of your concerns about the practice. But so executive authority and targeted killings, David.
So I want to start by agreeing with John that I don't think it's quite fair to say that this administration has given up on or ended indefinite military detention. Number one, because of the people at Bagram. Number two, because of all the people who are still at Guantanamo. Many of them there because of the administration's own self-imposed decision not to release them to places like Yemen, even though they've been cleared for release. And number three, because it seems that we are, in many instances, killing rather than capturing, and that's certainly not an adequate response. I want to disagree with John about finger pointing and suggest that he's being a little oversensitive. I think you can call it finger pointing. There's another word for it. It's called accountability. And when government officials engage in criminal action or illegal action, I think it's our responsibility as citizens, and none of us up here are anything other than citizens, well, citizens of one country or another. Yeah, I've just outed John's Mexican citizenship. I think it's our responsibility to say that they've done wrong, and that's, you can call that finger pointing, but to sort of put your head in the sand and say, yeah, well, we tortured, but let's not say we tortured, and yeah, well, we wiretapped in violation of criminal statutes that were on the books and led almost the entire Justice Department leadership to resign, but we shouldn't say that. Because that's finger pointing. I don't think so. I think that's accountability,
David,
and it's important.
that is not what I said.
Well, okay. So then I apologize if I misunderstood what you said. But let me turn to the drone issue, and I think here, I've been a critic of the drone policy from its inception, and much of the criticism has been that I don't think we should have a situation in which the president has the unilateral power to take a human being's life beyond the battlefield that is exercised in secret, pursuant to secret rules if there are secret rules, pursuant to secret processes if there are secret processes, with no accountability. That's just unacceptable in a democracy, and it is especially unacceptable when the president can kill his own people. So I'm generally one that I don't like distinctions between citizens and non-citizens, and I think it's problematic, deeply problematic, for the president to assert this authority vis-a-vis anyone beyond the battlefield. But there's a particular democracy problem when the president, who is representing us and is supposed to be constrained by the rule of law, exercises the authority to kill us in secret, in unacknowledged killings, as he did with Anwar al-Awlaki. That has changed, and I think that's good. He has acknowledged that he authorized the killing of Anwar al-Awlaki, and that 3 other Americans have been killed as collateral damage in other acknowledged killings. I think we should be acknowledging our killings generally, not just our killings of Americans, but that's a step in the right direction. He's also announced in his speech that he's put forth rules in a presidential policy guidance, whatever that is, that govern this thing going forward, and that's encouraging too. There were stories about how they were trying to come up with rules when they thought Mitt Romney might be elected, because they thought, oh my God, someone else might be pulling a trigger, we better come up with rules. And then when he got reelected, they slowed down in that process, and that's disturbing. I think, the deadline for rules is not when you might lose the election. The deadline is when you're killing a person. There ought to be rules in place. So it's good that the rules are in place. It's good, as Marty has suggested, that the rules are, again, off the battlefield, seem to have been, the threshold for killing seems to have been increased closer to a point where it might meet self-defense justifications under international law. It ought to be there. It might be there. I'm skeptical that it's there yet, but that's where it should be. And if it's moving closer to a situation in which the use of force to kill a human being is used only as a matter of last resort in self-defense of the nation, then that would be a good place to get. I'm not convinced that we're there yet, but I do see signs that we're moving in that direction. The number, and it's not just his words, it's also facts, the number of targeted killings has dramatically dropped in the last 2 years. And that too is a good sign. It's also a good sign that they now take the position that they will not employ a targeted killing unless there's a near certainty that no innocent people will be injured or killed. That sounds like a very high standard, higher than international law even demands. That's a good thing. What I'm still troubled by is the fact that the rules remain secret, the procedures remain secret. I don't think we have to give notice before we engage in an act of self-defense of this type, but I think the general rules and the general procedures should be public so that there is that accountability to the American public so that we can have an informed debate and decide whether this is the kind of authority that we think our president should have, and so other nations can know that. And that's important for our democracy. It's also important for international law generally, because this kind of activity engaged in secret, some of us, many Americans apparently, are comfortable with it when it's our president and when our president is President Obama doing it, but would they be comfortable with the leaders of China or Russia or North Korea using this kind of authority? And what we do creates a precedent for what other nations will do. So I still think that they have a long way to go in terms of public setting forth of the ground rules for targeted killings so that we can, in fact, assess whether they meet the standards of international law or just or don't.
All right, I'm going to jump ahead and ask my last question and then invite final comments before we open it up on any of these issues. My last question is for John, and this is an issue on which I think a good point, we do not have the full range of positions represented on this panel on all the many issues we're talking about. One issue where I think we have common ground on this panel is on closing Guantanamo, the desirability of closing Guantanamo. So I just want to ask John to introduce that issue. Actually, I'll introduce it a little bit by just giving you reminding you of some numbers that are relevant here. So during the Bush administration, 779 men were imprisoned at Guantanamo. By the time President Bush left office, more than 500 of them had been released. So then President Obama took office with 242 men still held at Guantanamo. 242, he said he'd close Guantanamo in a year. 161 detainees remain, over half of whom were cleared for release during the review back in 2009. So what accounts for the fact, we all agree we'd love to close Guantanamo, but there's been an utter failure to accomplish that, and how optimistic are you going forward? Just introduce the Guantanamo issue for us, please. Sure.
Well, as I said, a number of us had worked very hard in the Bush administration to close Guantanamo. And I was one of the first people to applaud. I think I went on NPR the day after the President Obama's announcement ordering the closure of Guantanamo to say I thought this was a good thing. I also knew at the same time it was going to be much harder than he thought, because I think there was a number of people, either inside or outside the administration, thought that the Bush administration had not been working very hard at it. Although, as Dawn said, we had transferred out 500 or so people. The problem is that the countries that these people came from, generally didn't want them back, or that the countries that did want them back, we didn't want to send them to. So that created a conundrum. Unfortunately, although I think President Obama's heart was in the right place on this initially, there was then a giant political miscalculation about how difficult it was going to be. And so the Congress, which was controlled at that point by Democrats in both houses, then voted down the president's signature foreign policy initiative. I mean, it's a remarkable thing. This would never have happened in a parliamentary democracy, that the president's major foreign policy initiative on his second day is immediately voted down by both houses of Congress. The Daily Beast actually did a number of years later, did just a month or so ago, a piece on this, you should look it up, on how the White House had bungled the closure of Guantanamo. And I think part of it was that Rahm Emanuel really didn't want to spend the political capital on it because he thought that it was going to be a loser, and he had other things to do which were understandable, like health care and so forth. But you can't just say that you want to close Guantanamo and then not put in the effort to try to do it. And I think what happened is, Congress then did pass all of these restrictions on moving people to the United States, even on transferring them to other countries. But again, it wasn't just the Republicans who were very tough on the issue, but also the Democrats who were running scared, and the administration then sort of lost interest in pursuing the subject. Then under pressure recently, just in the last few months, particularly after they had replaced their Guantanamo closure envoy, Dan Fried, and not replaced him with anyone, there was a real concern going into the second term that the administration was just not going to do anything at all, and pressure built up. The president did address it in the speech, and I think the jury is out, as Jamil said, is that just rhetoric when the president said he's going to redouble his efforts to close Guantanamo, or is he actually going to do something? He said he was going to appoint new envoys to help close Guantanamo. He still hasn't done that. He said that he is going to lift the restrictions on transfer to Yemen. He said he's going to restart the reviews of all of the individual cases, which had never happened in Guantanamo. But what he never did was he never addressed, even 4 years later, what to do with the most difficult cases of those people that this administration has reviewed and said that they really find to be too dangerous to release, but at the same time, they can't be prosecuted. So what will they try to do about that? And it is, in my view, it is not sustainable over 40, 50, 60 years. We cannot have a situation like Albert Hess, or Speer, was it, I guess, in Spandau, 60 years later, just still sitting there. There's got to be some agreement between Republicans and Democrats. And this gets back to my point of, yes, one can fault different administrations for things that they've done. The Obama administration, of course, we all know, is virtuous and only does good things. So the drone strikes are not criminal. Only the Bush administration engages in criminal activity. But whereas killing 3,000 or 4,000 people, that, of course, is just a policy difference. Again, this sort of stuff is not helpful if you want to get things done in Washington. If we want Congress to pass the laws that will allow us to close Guantanamo, the finger pointing is not helpful. You cannot bash someone on one day and then ask them to work with you to get something done. Right now we need to have the president work with the Congress to lift the restrictions on closure of Guantanamo, or it's not going to happen.
Okay, now in just a moment, I'm going to turn it over to all of you for your questions. First, I'm going to give, I think in the order we haven't really heard from people, Jamil, David, and Marty, brief moment to respond on Guantanamo or any of these issues as you get your questions ready. Jamil?
Well, I want to disagree with John about something and then agree with him about something. So I don't think that government officials of either party should be above the law or above criticism, and I think it's important that we have these kinds of conversations.
Can I just say, I have,
well,
has anyone,
John, let me
has-
just
have
say
I-
that.
Okay, John, I'm going to let you respond after Jamil.
Okay.
Let him finish his point, and then you can briefly respond.
But now let me agree with John about something and disagree with Marty and David. I think that this distinction between saying, saying that the Bush administration asserted the power to violate statutory law, and the Obama administration is following statutory law. There's a little bit of truth to that, but it's too facile. I mean, the Obama administration is, following the AUMF in the sense that it packages its arguments in terms of the AUMF, and it's following the Patriot Act in the sense that it points to the Patriot Act to justify the metadata program. But it has very aggressive interpretations of those particular statutory instruments. With respect to the AUMF, the administration is saying we have the authority under this statute to kill American citizens on the basis of standards we're not going to disclose, and on the basis of evidence we're not going to disclose. The metadata program, if you read Section 215 of the Patriot Act, which has all sorts of problems, and we've been criticizing it for 10 years, but if you read that section, it's plainly meant to allow the government to obtain static records, not to engage in real-time surveillance, let alone a 7-year program of sweeping up Americans' information about Americans' phone calls. So, I mean, I think it's, I suppose that between these two options, between the option of saying we have the power to violate statutory law and the option of saying we're following statutory law, but we have this very aggressive interpretation of it, I take the latter over the former. But those shouldn't be the only options on the table. And then, on this question of the AUMF versus constitutional authority, is it better if we retire the AUMF and move towards a self-defense model? I think that it could be better. I mean, I think it could be a good thing if we retire the AUMF and move to a self-defense model, but it matters how broadly we conceive of the right to self-defense. And one of the things that's very worrying to us at the ACLU is this phrase that the president used in his speech, continuing imminent threat, which is not a phrase that we'd ever heard before. And obviously it matters a lot what that phrase actually means. It could be a very narrow standard, or it could be a very broad standard. And beyond the question of what the phrase actually means, there's this question of who gets to decide whether that standard has been satisfied. And this is something that the administration has been consistent on, making the argument in court that whatever the standards are, it's the administration that gets to decide in the first instance and the last instance, the executive that gets to decide in the first and last instance whether the standard has been satisfied. We've been arguing that the judiciary has some role to play, at least in the case of American citizens. Now, David has outed me as a Canadian, so I don't know if I have any credibility on this point. But at least with respect to American citizens, the administration should have to present evidence to a court, and the court should be able to decide after the fact whether the administration was right, whether the executive was right to kill this particular person. And so, that's all to say that I think that all other things equal, it would be better to move towards a self-defense model and out of this idea that Congress has authorized a global war against some unspecified enemy. But it does matter what the standards are, and it matters who's applying them.
Okay, we only have 20 minutes left. I am going to let you speak. I just want to emphasize we only have 20 minutes, which is when we wanted to move to the audience. So burning points people need to make quickly. First, John.
Let me just say, I don't think anybody in the room heard me say that people should not be held accountable. I think what people said, because I said it 3 times, is that I am a believer in bipartisanship. I have served in administrations of both parties. I've respected the administrations that I have served in of both parties. I think the only way we can get things done in government if both parties actually work together. For those of you who have read my blog, I spend as much time criticizing the conservatives on the far right as the people on the far left. I'm a chronic moderate. I think, if you have served in government, and there are many people who came out of the human rights community, the civil liberties community, my successor as the legal advisor, Harold Koh, was a renowned human rights lawyer, served in this administration. Once you were inside the administration, having to factor in all of the things that you have to take into account, these things are quite difficult. And so, what I'm talking about is not about accountability, and I think that setting up those kind of straw men is unfair. What I am talking about is basic decency, working with the other side. And for the people in this room, unless you don't want to serve in your government, which I think really is a high honor, is you need to be able to work with people from the other side and not subject them to endless criticism.
All right.
In fact, I'm going to, on this topic.
So let's, I think we can, I think we can all agree that
No, we don't
bipartisanship.
actually agree
No,
on
I
that.
think on the point, I think you made a good point on that. We do not have the far right, and that includes many Senate Republicans who do not share your views, I think, on Guantanamo or the president's speech and some other issues as well. So I do think some of the call for accountability is aimed legitimately and substantively at other perspectives. You know, I just want to make that point. And I think, so I do want to get to questions. And so I wonder if Marty and David, do you have anything else that you would like to say before we open it up to the audience?
I mean, one framing point on, I actually have a lot of responses, but none of them burning
Okay.
to what others have said. But one framing point that is sort of a response to what all three of my fellow panelists have been saying. I agree with David, and I think the president does. I mean, it's reflected in his speech and other things, and in John Brennan's statements that when the U.S. engages in the use of force that results in the death of persons overseas, the U.S. ought to acknowledge that the ideal would be more transparency about rules, and in particular about what the effects of our use of force have been and whether we've complied with the laws of war and how many civilians have been killed. I think the president desires that too. I think there are constraints on that he's chafing against and that we need to deal with, the non-acknowledgement considerations that I've raised. But I think it's overstated to say that if we learned all the details of the legal or operational use of force overseas, that our public debate would change fundamentally. I think you'd all be pretty much where you are now. You'd know basically what you know now, and you would think basically what you think now about those processes. Not to say that more can't come out, but I do think that the descriptions, the detail on the use of force by drones by the United States over the last 3 years is, I'm pretty confident, far more detailed than any nation state has ever provided, including our own, about any use of force anywhere, including our own use of force in Iraq and Afghanistan. Every day the Pentagon is using lethal force and has been for the last 12 years. No one knows what their rules of engagement are, and no one's clamoring for those. The important point, I think, and it's raised by what we've all said, and Dawn, your Gitmo question, is I think we on the left, or the ACS sort of, we've forgotten how to legislate, in part because it's frustrating because Congress won't let the president do what he wants to do to close Guantanamo. All the work in the world, he could be making speeches every day. The House of Representatives is not going to repeal those restrictions on the Guantanamo transfers, and that's frustrating. But we know now, basically, at least rough outlines, about the use of force, where it's being done, how it's being done, whether U.S. persons are subject to the use of force, the fact that judges aren't allowed to review that, the surveillance programs and the like. And we don't have anyone, I don't know if anyone in this room or in this building is today drafting serious legislation to constrain. And Jamil, that's why it's important. The commitment to abiding by the rule of law is important because if we could get the votes behind legislation that would set the ground rules for surveillance or for targeted killing or for judicial review or for transparency, this administration would abide by those statutes if they could get through. I'm not saying they would approve of every recommendation. They probably wouldn't. But the point is that we have failed, I think, to come up with ideas about how the legislature should act and to work within the political system. How many of us talk to Senator Levin's staff every day, right, urging him to make changes in all of these things? We don't at all. And until that's done, I'm afraid that all the best intentions in the world of everyone here and the president are going to be stymied by a political system that is getting draft legislation only from one side and not the other.
Okay, I'm going to let David have the last 30 seconds.
I'm happy to go.
If you haven't, okay, questions.
In the spirit of
Now-
bipartisanship, I want
Thank
to.
you, thank you. So I am going to ask all of you to keep your questions very short. Do we have a microphone? Where's the microphone? Okay, so wherever the microphone goes, we will ask you to not make your own little speech. We all have strong views on all of these issues, but actually ask a short question. Okay, microphone, you go.
And to draw out a point of disagreement between David and John, but direct the question at Marty. So, and Dawn to
That's
some
what I do for
extent.
a living.
Well, so there's this question about accountability for torture in particular. And Marty, you're constructing this vision in which the Obama administration complies with statutes. The Convention Against Torture is the law of the land. Article 2 is unambiguous about there being no excuses, including emergencies or national security. And Article 12 is unambiguous that all credible allegations must be investigated. And you were talking about the Obama administration's legacy in terms of closing the door on torture, even while failing to follow the statute in this instance and ensuring that torture will recur by making it okay to commit the Bush administration's abuses. And I'm just curious how you square that, and particularly, Dawn, for you, and maybe for people who don't know, Don would be the head of the Office of Legal Counsel now if the Obama administration made a choice to pursue executive accountability for torture as it is required under international law. And I'm curious what it's like for you to be on the outside of this discussion because you fell on Rahm Emanuel's sword on this particular principle.
I think there's a lot of blame to go around for that. So I'm going
Bipartisan.
to let Marty answer.
So this is a long, a very complex question. And here's what I think. I think you're right.
But keep it short.
Yes, no. It's a troubling thing. But here's the problem when it comes to torture. I mean, the president. One really striking thing in the speech was the president said, he didn't say, John, the Bush administration tortured or they tortured. He said, we tortured. We, the United States of America. We tortured, we violated the law, we violated our most fundamental principles. It was wrong, it won't be done again. And I have a whole spiel about why I think the steps that he took in 2009 will effectively make sure it doesn't happen again going forward. Not forever, because 100 years from now it might, but it's effectively closed the door on that. What more realistically, and I agree that I think that the Senate report will come out and we'll get more of the granular details, but again, you guys know the story. The chief executive of the United States and the vice president of the United States, upon the advice of lawyers who told them that this was not illegal, approved this. They brag about it in their memoirs, right? There's no question about what happened or who's responsible for it. And so what is it exactly that what this accountability would consist of, but for, I guess, prosecutions of President Bush and Vice President Cheney, which I don't think would be particularly healthy, right, for our public right now. I'm not sure quite what more should be done. I agree, and I predict that by the end of the Obama administration, the Senate report, I hope it will come out in some form or another. And we'll have more details. But again, I don't think you're going to learn that much more that you don't know already. And I think the president has said, we as a nation, we did wrong. We're all responsible for it. I agree that the convention probably requires more than that, but it's not an easy question to figure out what more exactly we ought to do.
So I almost always agree with Marty, and the one area that I
This is scary because in the OLC the standard rule is Don Johnson is always right. So this means I'm wrong in this case.
thank you for that introduction to what I'm going to. So the one thing that I resist that you said, Marty, twice now is that if we knew more, it wouldn't really matter because we know enough.
No, I didn't say it wouldn't matter. I don't
might-
think it would
I
change
think-
the public dialogue.
Okay. So I think on this, David, that you can probably give us an example of two where it would be important for us to know more.
Well, if I had read the 6,000-page report, I could give you 6,000 pages of how it would be important to know more. But my assumption is that the Senate Select Committee did not write 6,000 pages saying what we already know, because it wouldn't fill 6,000 pages. And what we hear is that they have disclosed things that we did not know. So I guess my sense is, I think it's very good that the president has said we tortured and taken that kind of accountability. But I don't think that's enough. I'm not one who says these individuals have to be criminally prosecuted. But I do think that a formal commission, a bipartisan commission, is the minimal that a country should do when it engages in this kind of practice. And that's what the UK did after it used very similar tactics against the Irish in the early days of the Troubles. And that's what Canada did when it participated in a very minor way in our rendition of its citizen to Syria, Maher Arar, so that he could be tortured. And those official bipartisan commission findings of wrongdoing, I think, are really important. And again, they don't put anybody in jail, and I don't think people necessarily need to go to jail, although maybe I'll change my views when I see what's in the 6,000 pages. But at this point, I think we need something official, and the president saying the word torture in a speech is not really an official form of accountability. And that's something, I think the bipartisan commission is something we could do, and it worked in the UK. I think in the UK, there is a much broader sense of agreement that torture is just off the table. That's not true here in the United States. It's still the case that depending on how you ask the question, it's basically 50-50 among Americans whether we should be torturing or not when we're faced with terrorism. And we need to move beyond that. We're not going to move beyond that by one word in a speech by the president.
Okay, let's get to the next question.
John, I'm surprised that you're surprised that there's partisanship on important issues. Marty and I just went through an exercise where we read a brief by 45 senators on the unrelated subject of recess appointments in the NLRB case. It was almost word for word the recess appointments by President Obama. It was almost word for word the brief that Senator Kennedy filed in the 11th Circuit when the recess appointment was of a Republican Article III judge by President Bush. None of those 45 senators, and most of them were in the Senate then, came and said, yes, Senator Kennedy is right, and the 11th Circuit should disapprove of this recess appointment. So people take positions all the time depending on their political view. Now, obviously, it would be nice if we could all agree on something, but there are ways that we get around it and have traditionally gotten around it, and the way is that you mentioned that we put proxies out there whom we have faith in. And so you mentioned Harold Koh. Harold Koh gave one of the first speeches on these general topics, which was seen as a sign of what the administration was doing. Then there was obviously a leaked story, I won't mention any names, to a person on a very large New York newspaper that mentioned two names which most people in this room would think are two names we can rely on as having written what appeared to be the drone memo. And we have their assurance by having their names that something good is going on behind the scenes. Now, I ask you and I ask Marty, if this stuff can be done informally, what prevents it from being done formally? Why can't the people, the Harold Kohs and the two unnamed members of the Office of Legal Counsel who wrote the drone memo supposedly, if it can be discussed informally and through leaks and through speeches, why can't something more formal be done about it?
Well, let me take part of that. I didn't say I was surprised by the partisanship. We've had partisanship for a long time. I'm just making a plea for less partisanship in the national security area. I've personally gone and repeatedly testified in support of this administration, in support of its initiatives. That's not something I had to do. When they were trying to pass legislation to allow the president to comply with the ICJ's Avena decision, Senator Leahy asked me to come and testify, and I did that. I've repeatedly gone and done that. When members of this administration were smeared by the far right, calling them Al-Qaeda sympathizers, I was one of the first people to go and defend them. And I'm not saying this about me, I'm just saying I think this is the way all of us need to behave if we want, in the national security or the international law area, to try to bring up consensus in this town. So I'm not surprised by it. I just would like to see us all do a better job. With respect to the OLC opinions, I would invite Dawn, who might have been the head of the office, because I'm sure she would have ordered the release of the highly classified opinion written by two professors that reportedly said that it was legal to kill an American citizen. I actually, when I was asked this question, when I went and testified about drones recently, again, since the administration would not send up its own witness, I was invited to go up, and I answered questions about OLC opinions. And I was asked by Zoe Lofgren, well, why would OLC and the president refuse to turn over this opinion? And I said, because the president is entitled to private legal advice. The executive branch must explain its rationale. It has to explain to Congress its legal reasoning, but it does not, under our constitutional system, have to turn over the precise piece of paper that was given by the Office of Legal Counsel to the president, upon which the president relied. So to the extent the executive branch is not explaining to Congress its legal rationale, which I don't think that they've been doing, and I have expressed concern about that, then they need to do that. But do they have to turn over, under our system of separation of powers, the legal advice upon which the president relied? If Dawn were to tell me that she thinks that she would have ordered that piece of paper released, I would be very surprised.
Okay, I'll answer that question. So first, I would not have had the authority to order the release, as you know, would not have been my decision as the head of OLC. But I have publicly said that I thought, publicly and privately, that my view was what you just said, that it was not necessary for the administration to turn over the alleged opinion, but to fully explain the legal rationale for its policy that and program that it was carrying out. And I believe the administration has not. They've gone farther, and the speech was great. And there were 4 other speeches that gave us many details, but I think that more about legal rationale, and even more, as David said, about the program should be made public. But I agree, John, with how you described the obligation of the administration to explain the legal rationale for its policies, but not necessarily release the OLC opinion. I don't know if Marty wants to address this.
I don't want to address that.
I didn't think so. Okay.
But I do want to very quickly. I want to push back against the frame, and I think, John, you're selling yourself short in calling this all political disagreements. Of course, there's politics in this town. Jim's right. People change their views depending on who's in the White House. It's going on surveillance now to a certain extent. It goes on in recess appointments. It happens all the time. But I don't think that's largely what's going on here. And I don't. And John, if reports are right, you were one of the principal people fighting against torture and indefinite detention and in favor of closing Guantanamo within the Bush administration, not because of politics, because no one would accuse you of being motivated that way, because you thought it was the right thing to do, operationally, legally, morally, and the like. And I don't think the president was playing politics. There weren't good politics in criticizing the Republicans for exactly the reasons you gave. It's not a way to get the votes you need to do these sorts of things. The president was saying these policies were wrong. They were legally wrong. They were morally wrong. We are all responsible for them. I am trying my best to turn to other policies that I think are more sustainable and more legally justifiable. It's not a matter of politics. It's a matter of principle, which is, I assume, what you were acting on quite admirably in the Bush administration. And I know you mean publicly as opposed to behind the scenes, and you're trying to draw a distinction there. But I think I'm just going to resist the idea that this is all politics. It's obviously infusing it. But I think there's a lot of very, very deeply held principle and policy-based disagreements as well.
So we are.
And Jamil is itching to say something.
Yeah,
Yeah,
Donna,
we're
can I
about
just-
out of time, so let's just allow final comments. I'm
I can go to
sorry.
one.
What's that?
I can go to one, if that's the holdup.
Let me ask our people here, can we go a few minutes longer before the lunch? A little bit. Okay. Jamil.
So I want to make 2 very obvious points, and the first is that I think it's a bit rich. Everybody is so upset about the president's privacy. The president has should be able to maintain the confidentiality of the sensitive information, and if he can't, then there's going to be a chilling effect within the executive branch. And I think that there's something to that argument, but I wish that it were extended to the obvious places. So that's one obvious point. The second is that, this discussion we've been having about secrecy may not be quite the right word for it, because a lot of the things that we are saying are secret are not actually secret at all. We already have a pretty good idea of how many people were killed by American drones. We have a pretty good idea of even before the president acknowledged the killing of these 4 American citizens, we knew of 3 of them. We use secrecy, to characterize this problem, but really the problem is not so much secrecy as accountability. There's this kind of disconnect between transparency and accountability. And you see that through various legal doctrines like the Glomar Doctrine or the state secrets privilege. But one of the things that the administration, that the government is trying to do by claiming these things are secret, is not so much to keep the public from knowing them, but to keep the courts from doing anything about them. And this is, I think, a bigger problem than government secrecy right now. Not that we don't know, but the fact that we do know is kind of irrelevant. The fact that everybody knows these things doesn't allow the courts to hold people accountable for violations of the law or to examine the evidence that was the basis for a targeted killing. And this disconnect between transparency on the one hand and accountability on the other, I think is something that warrants more examination.
Okay. I don't think we have time for more questions, but I want to invite our panelists, starting with John down the line, a minute each to give us final thoughts. And Jamil, raised, we could go on, an additional really difficult, important question about the role of the courts in all this. John.
I think I probably said my piece other than to say, just to go back to where the reason that I come and do things like this is so there really can be a robust debate about these different issues. It is a lot different when you serve in government than when you serve on the outside. Every one of the concerns that has been raised, and I've been on multiple panels with David, Jamil, and Marty, every one of the points that has been raised, there's some valid concern to it. And in government, we try to take all of these into account and try to come up with the best policy that we can. And sometimes those are good policies, and sometimes they're bad policies. Marty alluded to it, and I won't get into it, but there are a lot of mistakes that were made in the Bush administration in the first term that we worked very hard to correct in the second term. But I do think that it is important to understand that the people who are in government are laboring hard. I have confidence in this administration. I don't agree with everything that they've done, but having been someone who has served in a previous administration, I've tried to give as much support to them as I possibly can, because I know how difficult it is when you are serving in these positions inside government.
David.
There was somebody whose name I can't remember now who wrote in the 1950s that democracy requires two things. It requires transparency from the government and protection of privacy for the citizenry. And I think what concerns me most, and this is a bipartisan criticism, it concerns me under the Bush administration, it's concerned me under the Obama administration, is that we've flipped that. So now we have a government that operates in significant measure in secret, using very disturbing authorities. Meanwhile, our lives are more and more transparent. And I think that has very troubling implications for our democracy going forward.
Jamil.
The only thing that I would add on this bipartisanship point is that, I always feel this when I come to D.C. and nowhere else, that the world is made up of Republicans and Democrats, and obviously it's not, and I think ordinary citizens, I don't think that our responsibility as citizens, and I use that word in the broadest sense of the term, but our responsibility as citizens is exhausted by our declaring our allegiance to one party or another. Sometimes both parties get it wrong, and I think we've seen that over and over again over the last decade. And there are more than two options on the table. Sometimes the Democrats have one thing to say and the Republicans another, and both of them are wrong. And I think that they're both wrong about surveillance. They're both wrong about targeted killing. And for those of you who live in D.C., just try to keep in mind that sometimes the world as it appears in D.C. is not the real, is not the whole compass of the world. There's more to it.
Canada, for example.
That's Marty.
That's a wonderful note to end on, but we are in the Beltway, so let me just take, let me take Jamil's point and say that it's the obligation of all of us outside the Beltway and inside then, I think, if we are troubled by the substantive decisions that the political branches and the FISA court, for instance, have made, it's our obligation to engage in the political process in a way that I think we have fallen down on. I'm just repeating myself now. And to think about how do we want, if these databases are going to exist, for instance, which I think is virtually inevitable, whether it's DNA or GPS information or metadata, what rules should we lay down to regulate how the executive branch and the FISA court and the Congress ought to act with respect to the use of that information? There's been virtually no discussion in all of the newsprint that's been expended in the last 2 weeks talking about what the rules ought to be. And this is something that I think all four of us commented on back in 2007, 2008. Striking thing about this new statute was that it had almost no specificity about the so-called minimization requirements that were going to be put in place. That's something it's hard work. Legislation and politics is hard, and it's frustrating, and it's never satisfying because you never get everything you want, but we have to re-engage with it if we really care about these issues.
So my final word is to agree with everybody, and to the extent they've said engage and work on these issues from the outside and the inside. Take every opportunity to work in government, in any branch at any level. You have the opportunity to engage. Also, to give my deepest thanks to all the panelists for giving up their Saturday morning to be here, and all of you for coming on behalf of ACS, and to invite you all to the networking lunch, which is beginning momentarily in the presidential ballroom, and then the closing plenary, which is covering the court inside the Supreme Court press room at 1:30. So thank you all.